Hey everyone, we are live. If anyone's tuning in right now. Oh, all right. Hey Adam. See if we can get Dan on here, and we'll start soon. Just gonna wait a couple minutes for Dan to pop in, and then we will get started.
Hello.
How's it going?
Good. How you doing?
Good. I broke out a new coffee mug for this event. I don't think you've ever seen this one before. It's Mickey's Pants.
Wow, very nice.
Yeah.
I went tried and true. Toronto Blue Jays.
So maybe we'll just wait. It's 12 o'clock now. Maybe we'll wait a minute for some more people to jump on and get started. Bust
Perfect.
some myths.
Sounds good. Yeah, see, we got a few people jumping in. Guess we should start the coffee then.
Hopefully we're pulling some people away from election coverage because that's the other thing that everyone's watching these days.
Glued. I think
Hope,
everyone is probably glued to it, or they've had enough at this point and they have turned it off and they're waiting to see something come across in the notification with something final.
yeah, well, they're tuning into us.
That's
It's a
right.
good break for everyone.
And
Hey
if
Sid.
if there is any breaking news, we will do our best to
Yeah,
keep.
well, we should have another screen on just so that one of us can make any major announcements if anything's
Okay.
coming out. All right, just after 12. You want to get started?
Yeah, sure. Let's do it.
All right, welcome everyone. I'm sure we're going to have more people join as we keep going, but uh, let's get started. Um, my name is Aaron. For those who don't know me, I am one of the co-founders of Epilogue, and Daniel, who you see as well, is the other co-founder of Epilogue. And most people don't know this, but November, it is officially a Make a Will month in Ontario. And so we thought that we would take an opportunity to do a series of these Instagram lives throughout the month where we can hopefully teach people a little bit about wills and estate planning. And today, what we're going to do is bust some myths. So, wills are something that a lot of people have heard about. I've had people say to me the first time they ever heard about a will is when their parents threatened to write them out of their will. But, again, people have a general sense of what a will is, what goes into a will, but I think few people have ever really seen a will. Certainly, before I got into practice, it's not something that I encountered a lot. I imagine that's the same for a lot of people. So there's a lot of things you hear about wills, and you're not really sure what's true and what's not. And so Dan and I figured we would kick off this series with a little bit of myth busting about wills, talking about some of the things that we hear day to day, and helping people sort of get down to the truth about wills. So let's get started. This is a big one. This is the first myth is something that I hear a lot. I know Dan hears it a lot too, and it's because of what we're doing now. Obviously, those of you who know Epilogue know that we make estate planning easy and simple by letting people do it online from the comfort of their own homes in about 20 minutes, and you don't need a lawyer. And so the question that we get asked a lot is, can I really make a will without a lawyer? I thought you need a lawyer in order to make a will. So Dan, can you help us bust that one?
Absolutely. So just before I do, I will say one thing, which is, as Arin mentioned, it is Make a Will Month in Ontario. And Arin and I are Ontario lawyers. And so most of what we'll talk about today is Ontario specific. I mean, a lot of it applies sort of across the country, but we'll make sure that if we're saying something that is specific to the laws of Ontario, we let you know. Because as you may or may not know, we are available in Ontario, BC, and Alberta. So there could be people watching from any of those provinces. So we'll do our best to let you know if we're saying something that's specific to one province as opposed to another. So yes, one of the things that we hear all the time is, can I really use an online service to make a will? I thought you needed a lawyer. So the answer is definitively no. You do not need a lawyer to draft your will. There are certain times or circumstances where it would be wise to speak to a lawyer, but even in those, it's not legally required that a lawyer draft your will. In fact, you don't need a lawyer to draft your will. You don't need a lawyer to be a witness to your will. You don't need a lawyer to stamp your will or any of those things. For basic estate planning, it is perfectly reasonable to use an online service like ours, we believe, to get your will done. I'll note that there's one part of the will making process in Ontario where you might need to bring in what's called a commissioner, which oftentimes is a lawyer. And that is not with respect to your actual will, but it's an affidavit that would be signed by one of your witnesses. It's not required to make your will legally binding, but it is considered best practice to get that document done. And when you do, that document needs to get witnessed by a lawyer. But that does not need to be the lawyer that drafted your will. That lawyer doesn't need to look at your will or know what your will says. They're just confirming that you are who you say you are. So we can say that myth is busted. You do not need a lawyer to draft your will. You really do not need a lawyer to sort of play any big meaningful role in the sort of the creation of that document. Only if you've got some specific circumstances that make your estate planning more complex, is it a really good idea to go and speak to a lawyer. Arin, any other thoughts?
Yeah, I've always thought, like, I mean, the will making process is so interesting because what actually makes a will legally valid is the way that it's signed. You know, in most provinces, a will has to be signed with two witnesses present, basically sitting in the same room as you, watching you sign the will, and then they sign the will too. And if you do that, that's a valid will. And it could have all the fancy language in the world, or it could just be sort of, you know, a lot more plain and simple. But if you do that, if you follow that formal procedure, then you've got a valid will. Like you said, no lawyers necessary.
Wonderful. Okay, so I will ask the next question or bring up the next myth, which is something that, again, we hear all the time, which is either I'm too young to make a will, I don't have enough stuff for it to make sense for me to make a will. You know, obviously that's sort of call it our generation, sort of people in and around our age demographic who are maybe hearing about wills for the first time and say, you know what, I know that I'll get a will eventually, but now's not the time. I'll do it in the future. I'll do it when I have more stuff. So curious to get your thoughts on that.
Total myth. Yeah, so I think a lot of people, I mean, like I said off the top, people don't really know a lot about wills. And when you ask somebody, you know, what is a will, most people would say, oh yeah, that's where you sort of give away your stuff, right? That's when you're saying, you know, I want my guitar to go to this person and I want my record collection to go to that person, right? But I think to bust this myth, we need to understand a little bit more about what a will is, right? And a will isn't really about your stuff. It's about your family. It's about your loved ones. It's about, you know, what you're going to do for these people once you're no longer here. And so if you just think about a will In terms of giving away your stuff, well, then, yeah, of course, you say, well, I don't have a lot of stuff to give away, so what do I need a will for? But let's talk about, somebody with young kids who might not have a lot of stuff, but they've got children, right? And so one of the really important things that goes in a will, especially when you have young kids, is naming a guardian for them. What if something happens to you, or you and your spouse or partner? Well, who's going to look after your kids? Well, a will is where you can name the person that's going to be the guardian for your kids, right? And so again, let's shift this from thinking about a will about a will is just about giving away my stuff, to a will is about how my family's going to be taken care of. There's another piece to making a will, which again, a lot of people don't appreciate. It's about who's managing this process, right? So somebody passes away. Well, let's say you've got a bank account and it doesn't have to have a lot of money in it. Let's say it's a few $1,000s. Who's walking into the bank and taking control of that bank account? Who's going to be there to distribute, even if it's just a few $1,000s, or even if you just have a car, right? You can have an idea about who you want to get that car, but the bank's not just going to let anybody walk in with a death certificate and say, oh, give me access to their account. One of the things you do in a will is you name what's called an executor. An executor, again, one of those words that people probably have heard before, but they're not really sure what it means. An executor is the person that's named in the will who has the legal right to go in and talk to the bank and assume control of your bank account. Again, even if it's just a few $1,000s, they have the right to assume control of that account. Or if, like I said, if you have a car, they have the legal right to go in and assume ownership of that car, not necessarily for themselves, right? You're going to write a will that's going to talk about what happens to your bank account or what happens to your car. But this person has the authority and the responsibility to take those assets and sort of carry out your wishes. So, when talking about making a will, you're not. It's not that not having enough stuff is not a reason to do it. Because if you don't have a will and you haven't named that person, well, it becomes a court process to figure out who's going to get control, who's going to have the authority, and the few $1,000s that you have in your account, it can disappear very quickly if you have to go to court and figure out exactly. Even if everybody's getting along, it's a process that'll take time and it'll cost money. I see a question just came in. Tackle it now because we're talking about executors. Can your executor also be a beneficiary of your estate? Yes, absolutely. There's nothing that stops an executor from also being a beneficiary of your estate. It's very common, in fact, for people to name family members who are beneficiaries, who are actually getting the stuff out of the estate, to name a family member as a beneficiary as well. Dan, anything to add on that busted myth?
No, I think that is. I think you did a great job, and it's very true. It's as we've said before, it's less about what you have and more about who you love, and making sure that you are sort of making some wise decisions in that regard. So by naming an executor to manage the process, by naming a guardian, those are big decisions that you have to make, and that doesn't hinge on how much money you have. So yeah, I think that's good.
All right. So the next myth that I'm going to throw at you is kind of takes off the last one a little bit. I said, we talked about how it doesn't matter how much stuff you have. It's still important to have a will. People say, I'm too young to have a will, right? And we've heard people say this as well, right? My family's not done yet. My partner and I, we have one child together, but we're going to have more. So I shouldn't make the will now. I'm going to wait till my family is done, or I'm going to wait till I accumulate more assets, and that's when I'm going to make my will. It's not the right time to make a will. So have at it.
So that's a myth too, for sure. I think a lot of people have this idea that a will is a document that you create once and you never change. And so the idea is that I should wait until the perfect time. I should wait till my family is settled and look the way it's going to look. I should wait until I have more money, when I'm more senior in whatever it is that I'm doing, because that's the time that I'm going to make this one single will, and that's the will that I'll have forever. And that's just not true, because the will is a document that should reflect your wishes when you are making it, and that can be changed to continue to reflect your wishes later. So if you name a guardian in your will today, and in 5 years you don't think that person is the right person for the job anymore, then you can change it, and you should change it. And same goes with executor. You name an executor today that you think should be the executor. If something should happen to that person, they're no longer available for that role, you should change your will so that it reflects the wishes that you have on that day. I think that sometimes when people get their wills drafted by lawyers, the thought of going in to make a change comes with sort of the knowledge that there's going to be a cost to it. And sometimes someone's almost disincentivized from going in to change your the guardianship provision because you don't want to pay to do that. And so you want to wait until you think that you're at a point where you're going to make the fewest changes going forward. And I don't think that's really the way that this should be viewed. So I think you should think about your will as a document that you are going to change, that when you make it, it should reflect your wishes on that day, with the knowledge that you can continue to change it. You can change it in 2 weeks, in 2 months, in 2 years, or never. But you have the ability to change it as often as you wish so that it will be reflective of what you want to happen. So I would say, don't wait on the basis that there's going to be one day that stands out to you as the day to make your will, because that's the day that your family is settled and you've got complete certainty around that, and the amount of money that's in the bank tells you definitively on that day, okay, here's the day to make my will. That day isn't going to come. So what's sort of the best thing to do is make a will and continue to change it as the need arises.
Yeah. And I mean, when we were building Epilogue, one of the things that was really important to us was to give people the ability to make those changes when they want to. And so, we built a platform in a way that if life changes, just come back on, make those changes, create a new will, print it out, sign it, and you're off, and it doesn't cost you anything. And yeah, you're right. I mean, cost should not be a barrier to make sure that your wishes are reflected in your will. One of the other things that I think is worth pointing out here is that when you have a really well drafted will, you don't necessarily have to update it, every time your family grows, right? And so, when you and I would draft wills in practice, right, and somebody wants to divide things equally, say, between their kids, which is very common from a planning point of view, well, you just put that right in the will. I want to divide everything equally between my kids. And so if you write your will when you have 2 kids and then you have a third kid, you don't necessarily have to go rush out and update your will because it's already accounted for. The will doesn't specify 2 kids versus 3 kids. It's written in a generic format. And so, again, when we built Epilogue, we built it along the same way, in a way that produces wills like a lawyer would draft a will, basically.
That's right. Okay, we'll move on to the next one. This is an interesting one. And this is the thought that if you don't have a will, the government is going to get all of your stuff. What's interesting about this one is that you would think someone who believes that would go ahead and take the steps to actually create a will, which also isn't always the case. Someone might not create a will and still believe that by not creating a will, there's a chance that the government is just going to come in and take all of their stuff. So on that question, if you do not have a will, does the government get all of your stuff?
In 99.9% of cases, the answer is no. It is possible, but extremely, 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 extremely rare that could happen. But I'm actually going to tie this to another myth, which is kind of the flip side of it. Because, yeah, some people say, okay, if I don't have a will, the government's going to get all my stuff. That myth busted. But people also think, oh, if I don't have a will, then everything will just go to my spouse automatically. That's the way it works. Well, that's also a myth. And so, I think it's important to bust that myth at the same time. What happens when somebody dies without a will is, like, the technical legal term is intestate. That's what they're called. They're said to have died intestate, which means they don't have a will. And every province has a set of rules that get followed when somebody dies without a will. So the rules set out exactly who gets what. So in Ontario, for example, if you have a spouse and you have no kids, then yes, your spouse will get everything. Though that's the intestacy rule when somebody dies with a spouse but with no kids. But once kids are in the picture, so let's say you have a spouse and you have kids, it's not the case, at least in Ontario, that your spouse gets everything. Your assets actually get split between your spouse and your child or your children. And that could have a whole host of negative consequences. There are situations that arise where, instead of the spouse owning the family home, if one person passes away, the family home is owned between the spouse and the kids. And then things that are just make things a lot more difficult to manage happen. So, for example, the children, if they're minor children, then the government has to step in because the children can't technically own property. And so, again, it could be a major headache. Um, one of the other quirks, at least in Ontario, is that when I say spouse, I'm referring only to a legally married spouse. So you could have a common law partner, and they may have been your partner for 2 years, or they may have been your partner for 22 years, but it doesn't matter. The rules of intestacy are that if the person is not legally married, they don't have an entitlement. The only way around that is to either marry the person, but again, if that's not how you want to live your lives, then that's choice is up to you. So the way to fix it is to actually get a will where you name your common law partner as a beneficiary under your will. If you want them to get everything, you have to say that in your will. In terms of when the government gets everything, like I said, it's a really, really remote possibility because, like I said, if you have a spouse and no kids, at least in Ontario, everything goes to them. If there are kids, then it's split between spouse and kids. If you have no spouse and no kids, then the next rule, this just sort of follows in order. So everything would go to your parents or one of your parents if only one of them is alive. If you don't have parents who are alive, it goes to siblings. If you don't have siblings, it's aunts and uncles and then cousins. So it sort of follows this whole path. And if you get all the way to the bottom and you don't have any sort of close enough relatives, which for most people is not the case, but if that happens, then everything would go to the government. But again, it's a really rare case. It can happen. As a general rule, it does not. Anything else on that, Dan? Or have we
No,
sufficiently busted that one?
I think we're good there. Let's move on to the next one.
Okay, so this is a fun one. These are all fun as far as I'm concerned. um, okay, let's say we've convinced everybody who's listening to this and everybody who comes to our site and reads the stuff that we put out that they need to get a will and that it's really important to have one. But the thought of it is so daunting because I have to collect all of my banking information and all of my insurance information, and I have to make a list of everything I own or everything I might own in the future because I have to put all those things in my will. Myth or fact?
Myth. So, it is a good idea to what I'll call sort of take inventory about what you have, just to understand in a really general sense, what is it that I own? So, do I have money in the bank? Understand the approximate value. Do I own a house or a car? That kind of stuff, just to understand sort of what it is today. And that's more about understanding that that's what you are going to be leaving to the next generation. And so in a general sense, to understand what it is. But it's not the case that you are going to need to mention each bank account by name or your car and your jewelry and do a full inventory of all the items in your house. Because when it comes to your will, that's not how it's going to be distributed. Usually, what people end up doing with what we'll call the bulk of your estate, or what ends up being called the residue, which is sort of the stuff that you own, that's more likely going to be distributed in shares. So you're going to say, I want to leave, or let's say if you had two kids, you said, I want to split it into equal shares so that each child of mine will get a share. So you're not saying in your will, I want to leave the money in this bank account for this child and the money in that bank account for that child, because what happens over time is that those amounts change. And maybe you close that bank account and it doesn't exist anymore. So by trying to get too specific to itemize everything you own and decide where each of those things are going to go, it ends up being really problematic because it would mean that every time one of those things change, you'd have to go and change your will. So, of course, you can leave specific items to specific people. So if it's the case that you have an art collection or you have jewelry or you have family heirlooms and you want to say, yeah, I want to leave this to my cousin, you can do that. And you can go in and say, what are the items that I actually want to leave to specific people? But outside of that, what you're going to do, more generally speaking, is sort of split what you have into shares and leave those shares to people. And it's actually going to be your executor's responsibility to make sure that those shares are distributed correctly. Anything to add there?
Nope. I think you covered it, and I think the point you made is a really good one. If you was actually somebody asked me this the other day. If I list something in my will, like a specific thing, and then I don't own it anymore when I pass away, like what happens to it? And so the answer there generally, again, at least in Ontario, is if you call it a specific item that you then sell years down the road, you don't own anymore when you pass away, it's as if that gift doesn't exist. So the person that you would have left that, your 67 Camaro to, if you sell your 67 Camaro years later and it's not around when you pass away, then that person doesn't get a gift. But like Dan said, it would really be a difficult thing if you had to list everything and then had to update your will every time your assets changed.
Okay, I think we got time for one more here. A fun one also, like you were saying. This is a bit of a strange one, and I think that this comes about because of movies and TV shows in Hollywood and things like that. So people believe that there is a formal reading of the will, and they envision a lawyer's office with a long wooden table and the lawyer sitting at the head of the table, reading through the will and letting people know what they will be getting or not getting. And it's always very dramatic when it's done. So does that happen? Is that what happens when someone passes away, that there is a formal reading of the will where everybody is inevitably shocked by what's in
I saw that happen once, and it was in a daytime soap opera. But
it?
but in real life, that does not happen. But I have had clients when I was practicing call me after somebody passed away, and they asked this question. They said, "So what's the procedure? We had the will at our office, and they said, do we come in and do you read the will to us?" And in that particular case, I said, no, I'll email you a copy of the will. You can read it, and then we'll come in, we'll sit down, and we'll talk about it. But there's no formal reading of the will. You don't need a lawyer to read the will necessarily. I mean, when somebody passes away, often a lawyer is a good resource because they can sort of help guide you through that process. But there's nothing about a lawyer reading a will that makes it official. And in fact, I mean, what you describe as people being shocked when they hear about what's in the will, I mean, one of the things that you and I always tell people is that once you're done making your will, you should discuss it with people. People shouldn't be shocked and surprised by what's in your will. What I used to tell clients is that you don't want people to be shocked or have questions or wonder why you did something, because if the first time they're seeing the will is after you're gone, well, you're not there to answer those questions. You're not there to explain what your thinking was. And so rather than have people be shocked by what's in your will, we encourage people to make their wills, but then take the time to discuss it and to let the people that they've named as executors know that they're named as executors, and to have the conversation with the people that they want to name as guardians to say this, we're making a will, we'd like you to be a guardian of our children, and let people know where the will is stored so that it's not a shock and people aren't asking questions when you're no longer around to answer them.
Okay, very good. So I think that brings us to the end of today's Instagram Live. I hope we have sufficiently busted the myths And we will do this again next week. Next Friday, same time, with a different topic, still in the world of wills, and have another discussion.
Yeah, so and if there are any other questions that you have, if there's things that you've heard about wills that just don't seem like they make a lot of sense or you're not sure if they're right, why don't you just, drop us a line or drop it in the chat, now, and we can address those next week when we go live again.
And I
Thanks.
see a few people who just joined towards the end. So a quick shout out to Kyle and a quick shout out to Ashley Gordon. Thank you so much for joining us today.
All right, thanks everyone. We'll see everybody next week.
Bye, everybody.